Chapter 9, Child Support. After reading this chapter, you should be able to explain what child support is and when, how, and to whom it is awarded. Distinguish between child support and spousal support. List primary initiatives the federal government has undertaken in the area of child support. Identify major jurisdictional issues that arise in child support cases. Explain what child support guidelines are and how they are applied. List factors courts consider when establishing child support orders. Explain when and how a child support order can be modified. List ways of enforcing child support orders. Identify the primary tax implications of child support and identify the kinds of tasks paralegals perform in child support cases. First of all, explain what child support is and when, how, and to whom it is awarded. What is child support? Child support refers to a parent's obligation to contribute to the economic maintenance of his or her child, including adopted children. Child support issues arise in many contexts, including divorce, separate support, paternity, and abuse and neglect actions. Child support may be temporary while an underlying action is pending, or permanent, though it remains subject to the continuing jurisdiction of the court. Who has to pay child support and to whom? Child support is most commonly paid by a non-custodial parent, who is known as the obligor, to a custodial parent, who is known as the obligee. Sometimes a parent may be ordered to pay child support to an agency, such as a residential treatment or juvenile correction program. Persons ordered to pay child support can include parents as well as third parties who act in loco parentis, meaning in the place of a parent. The majority rule is that absent an agreement or a court order, a step-parent will not have a duty to support a stepchild. A man who has acknowledged paternity may be ordered to pay child support even if DNA evidence proves him not the father. When does the child support duty end? There are significant jurisdictional variations. The duty typically continues until the child's emancipation. Emancipation refers to the age 18 in most states and in Ohio. Act or occasion that frees a child from the control of the parent. So typically in Ohio, we look at emancipation. If we have an 18-year-old child who is still in high school, for example, emancipation doesn't occur until the child has graduated high school, because the residential parent, the custodial parent, still has an obligation to continue to support that child through high school. So if the child turns 18 in January, the duty of support will continue until the child graduates high school. In some states, a parent may remain liable for support of a disabled child beyond the age of 18, or when the child pursues a certain type and amount of higher education. Ohio is one of those states that does enforce and order child support obligations for disabled children beyond the age of 18. Distinguish between child support and alimony, or in Ohio, spousal support. Child support is a right of the child, cannot be waived by agreement between the parties, is calculated using federally mandated guidelines developed by the states, remains under the continuing jurisdiction of the court, can be modified based on a substantial change in circumstances or on a periodic review, does not terminate as a result of a parent's remarriage, is neither deductible to the payor nor includable in the income of the recipient, is not discharged in bankruptcy, and is given priority in payment. Now, when it says it cannot be waived by agreement between the parties, that is true to an extent. The courts do allow for $0 child support awards in some cases of shared parenting, etc. If a parent is receiving public assistance, however, that throws a wrench in things, and typically child support cannot be waived in those circumstances because the state has a right to reimbursement for funds paid out as public benefit. So there are certain circumstances where that is actually not true. It can, in some circumstances, be waived. However, oftentimes you'll have a mother, for example, who will come in and say, the father wants to waive, sign over his parenting rights. And what they're essentially saying is that the father doesn't want to pay child support, so he wants to terminate his parental rights and responsibilities. Well, that's fine as far as terminating of his parental rights. However, the courts typically don't allow a termination of responsibilities. It's the child who is entitled to the support, and it's not the mother's right to waive child support in that circumstance on behalf of the child. Alimony or spousal support is a spousal duty based on one party's need and the other party's ability to pay. Although, again, spousal support is not always necessarily need-based. Can be waived in a valid agreement between the parties in most states. It can be waived in Ohio. Can be waived. It is not calculated according to guidelines governing amount or duration in most states. There is case law in the state of Ohio that says that spousal support must be determined on a case-by-case basis. So while there is a general formula for determining what amount would be fair, there is no statutory formula utilized like there is for child support. It is determined on a case-by-case basis. May be modified based on a material change in circumstances unless contrary to a statute, decree, or surviving agreement of the parties. Will not be terminated by remarriage of the recipient in most states. Not true in Ohio. Well, if you have a provision in your decree that states that typically if it's a negotiated agreement, you're going to have a provision that's going to state that spousal support will terminate upon the death, remarriage, or cohabitation of the recipient spouse. So if that provision is in there, then it will in fact terminate on one of those terminating events. It is usually tax deductible to the payor and income to the recipient, and is usually not dischargeable in bankruptcy. List the primary initiatives the federal government has undertaken in the area of child support. The primary initiatives taken by the federal government are designed to contain the cost of public assistance programs, address inadequacies and inconsistencies in child support awards across the states, and streamline and strengthen enforcement, especially when multiple states are involved. It established the Office of Child Support Enforcement, the OCSE. It required the states to develop numeric formula-based child support guidelines to be used in establishing child support awards. It required the states to have a procedure for establishing paternity anytime before a child reaches age 18. It required the states to seek medical support for children as part of any child support order. It strengthened enforcement efforts. It maintained creation of federal and state case registries and directories of new hires. It mandated creation and adoption of the Uniform Interstate Family Support Act, the UIFSA. It created the Transitional Assistance to Needy Families Program, the TANF. It required each state to develop a comprehensive child support program run by a single state agency to be designated its 4D agency. You'll hear the term 4D agency and 4D application, etc., utilized when discussing child support and spousal support, because actually the Child Support Enforcement Agency in some cases will be the agency that collects and distributes spousal support payments as well as child support payments. The primary responsibilities of the state's 4D agencies are to assist in establishing paternity through testing of putative fathers, assist with location of non-custodial parents through state and federal parent locator services, facilitate entry of support orders after paternity is established, periodically review child support awards, and enforce existing awards. The services of 4D agencies are available to parties receiving public assistance and to those who are not. The CSEA does do periodic reviews of child support awards where they will send out requests for documentation of current income, etc., to the payor and the payee spouse, the obligor and the obligee, and they will review to make sure that the child support still is in line with what the party's financial situation is, and they can do administrative adjustments to the support awards if they find that it is not in keeping with the current financial position of the parties. Identify major jurisdictional issues that arise in child support cases. Subject matter jurisdiction over child support cases usually rests in family courts, but may also be in juvenile courts, district county courts, and other courts that deal with matters pertaining to children and their parents. Personal jurisdiction over the defendant. Each state has its own statutes governing the ways in which personal jurisdiction over a defendant may be obtained. We've talked about service before and jurisdiction, personal jurisdiction over parties to the proceedings. There's personal service, service by publication, etc. Obtaining personal jurisdiction over a resident defendant, usually by personal service, but sometimes the defendant's whereabouts are unknown. Obtaining personal jurisdiction over a non-resident defendant in the petitioner's own state, usually under UIFSA or a state's long-arm statute. obtaining personal jurisdiction over a non-resident defendant in his or her own state, usually by using the services of the state's forwarding agency, with the agency acting on behalf of the petitioner with or without the assistance of private counsel. Where does continuing jurisdiction lie once an initial award has entered? So under the UIFSA, there should be only one valid child support order enforceable in all states. Once a court issues a valid child support order, that court will have continuing exclusive jurisdiction for purposes of modification as long as either parent or the child continues to reside in that state, or the parties file written consents that another state assume jurisdiction. If neither party nor the child continues to reside in the issuing state, that court will lose continuing jurisdiction, and a court in another state can acquire it. If an order is sought in multiple states under the UIFSA, preference will be given to the child's home state. Explain what child support guidelines are and how they are applied. Child support guidelines are guidelines developed by the states in response to a federal mandate. They are presumed to generate an appropriate amount of child support given a particular set of assumptions and circumstances. You can look at page 307 for the Missouri guideline form. You can also do a search for the guideline child support calculation for the state of Ohio. They apply to all child support orders, whether at establishment or modification. Guidelines incorporate various descriptive and numeric criteria, and formats vary from state to state. They must provide for children's health care needs. This has been a major change in child support just since the time that I started practicing. Well, I guess I've been in practice for 15 years, but it has been a major change since I've been in practice. There is now a whole body of new language that has to be included in child support orders relative to cash medical support to assist with covering expenses of a child when private health insurance is available and when it is not available. So there is like I said, an extensive amount of new language that has to be included in orders relative to healthcare. They must be reviewed every 4 years and revised if necessary. Application of the guidelines produces a rebuttable presumption of the appropriate amount of child support to be ordered. An order that deviates from the guideline amount must include written findings by the court about why the deviation was required. So oftentimes with shared parenting plans and negotiated divorces or custody arrangements, you'll see a deviation in child support if the parties are cooperative and sharing expenses, etc. With any deviation from the guideline support amount, you have to file a document contemporaneously with the support amount, the separation agreement, shared parenting plan, whatever your final order is going to be. You have to file a separate document called Findings of Fact and Conclusions of Law. The purpose of that document is to outline exactly why you are deviating from the guideline amount. If those circumstances change down the road, the court and the CSEA needs to know what the basis for the initial deviation was. And so you have to spell that out in your findings of fact and conclusions of law, justifying any deviation from the standard support amount. If you're just going with guideline support, you don't need to file the separate findings of fact. What income are the guidelines based on? The guidelines must consider all earnings and income of the non-custodial parent. In many states, the income of both parents is considered. In Ohio, the income of both parents is considered. Income is usually defined as income from all sources, but what will be included varies according to federal law, state law, administrative law, and case law. Typically, income will include support received from another person, cash and gifts from family members, lump sum severance pay, annual bonuses, lump sum personal injury settlements, gambling winnings, SSDI benefits, reimbursements received in the course of employment, and retirement benefits with some limitations. Typically not included in income is means-tested benefits such as Pell Grants, TANF benefits, food stamps, and supplemental Social Security income. Can income be imputed to a party? Imputed income is income attributed to a party based on his or her earning capacity rather than on actual earnings. Most states will impute income to a party, either the obligor or the obligee, if appropriate, and some states have a formula for doing so. Example of when income might be imputed is voluntary early retirement, voluntary unemployment, or underemployment, loss of gainful employment due to a party's own wrongdoing. Most courts will not impute income if there is a good faith reason for unemployment, such as a physical disability. Typically in Ohio, in cases absent some physical disability and inability to work, The courts will impute income to both parties if to either the obligor or the obligee. And typically what they look at as the imputed income is either an average of the parties' previous 3 years' earnings, if there is an earning history there, or if the party has not worked for an extensive period of time, they'll look at imputing minimum wage to the party who does not have a standard steady income. List factors courts consider when establishing child support orders. Extraordinary expenses. These are expenses that are not reasonably predictable or consistent child to child, such as medical expenses that are substantial in cost and or duration. Multiple families. The traditional rule is first families first, meaning the obligor usually cannot request a downward modification based on having a new family, but may use the cost of supporting a new family as a defense to a claim for an upward modification. So this means if a party is divorced, the obligor spouse remarries or has additional children for whom they are responsible for supporting, they can't use that new family as a basis for a downward deviation in support for the first family. It does in Ohio factor into the child support calculation. In fact, they can do a recalculation of support to determine whether he is entitled to an adjustment in the support based on having additional family members or additional children, but it is not it's not typically an avenue by which parties can reduce their prior support amount. Cost of living in a particular geographical area, standard of living, although the basic purpose of child support is to provide for the child's survival needs. There are some additional variables that may be factored into guidelines or be treated as reasons for a deviation, such as custodial and visitation arrangements, number and ages of the children, financial misconduct of either party, existence of an agreement, and needs, liabilities, and resources of the parents. Several states provide that if a child continues high school past age 18, child support will continue until he or she finishes high school or turns 19. That's the case in the state of Ohio. There is a range in approaches to higher education, but the current trend is absent an agreement, parents will not be required to pay for such expenses. That is also the case in the state of Ohio. You are not legally required to pay for anything for your child once they have emancipated or attained typically age 18 or 19 if they're still in high school or graduated high school. Deviations in the child support amount may be made if the child participates in special needs or gifted programs, necessary tutoring, etc. Explain when and how a child support order can be modified. Based on a self-executing provision and an agreement of the parties incorporated in a court's decree, should be tied to the party's actual financial circumstances, can be modified based on proof of a substantial change in circumstances. Usually the change must have been unforeseeable. The burden of proof is on the petitioner and may be satisfied by a showing that there is a specific level of difference between the award and the current guideline amount, such as 15% in some states. Look at 320. Page 320 and I'm sorry, pages 319 and 320 regarding whether or not incarceration is considered a change in circumstances to justify a modification of support. Based on a periodic review and adjustment of the orders by the state's 4D agency, again, they do these periodic reviews and will request documentation of current income levels and employment benefits, etc., to verify the amount of support. The modification action can be brought by a party or by the state's 4D agency. The petition is not always granted, but may be if the court is persuaded the prior award is inequitable and the change is in the best interest of the child. Ways of enforcing support orders. Based on a self-executing provision and an agreement of the parties, once an award is made, it can be enforced in any state where the obligor or his or her assets are located. If the obligor is a non-resident, the obligee can travel to the defendant state to seek enforcement, or he or she can use the 4D agency in his or her state, the initiating state, to register the order in the defendant state, the responding state, for enforcement. They can be enforced through contempt actions, either civil or criminal. They can be enforced through income withholding, which is typically how support is withheld. Sometimes in certain circumstances, we will, with self-employed individuals or in other certain limited circumstances, we will have support deducted from a savings account or something else. But typically, they're not direct pay anymore. There's usually an income withholding, and those withholding orders would go on at the time of the original order. Usually, it's going to be, withholding orders going to the person's employer. Criminal prosecutions under federal or state law for criminal non-support. Seizure of assets. Tax refund intercepts, these are very common as well. If there is an arrearage due and owing for child support, the 40 agencies will intercept tax refunds. Unemployment compensation intercepts, license denials or revocations, passport denials or revocations, and credit reporting. So they can deny or revoke or suspend professional licenses, driver's licenses, all in an effort to enforce these child support orders. Identify the primary tax implications of child support. Child support is a tax-neutral event, meaning it is neither deductible to the payor nor includable in the recipient's income. The general rule is that the custodial parent is entitled to claim the child as a dependent for tax purposes, resulting in an adjustment to that party's gross income. The parties may agree to an alternative arrangement. Typically, in shared parenting type circumstances, they will alternate the tax dependency exemption. In Ohio, actually, the courts tend to prefer to award the dependency exemption to the party who is going to recognize the biggest tax benefit from it. So if you have a stay-at-home mother or a person earning a significantly lower income who is not going to recognize much of a benefit from the tax dependency exemption, the court may award it to the other party, because what's going to happen, even if that party isn't paying their child support or isn't current on their support, if they're receiving another tax benefit or tax exemption, then that will make for a larger tax refund that they can then intercept and utilize to cover the child support obligation or any arrearage that is due and owing. The parent claiming the exemption is also entitled to the child tax credit, resulting in a credit against his or her tax liability rather than an adjustment to gross income. Identify the kinds of tasks paralegals perform in child support cases. So they complete child support guideline worksheets for review. Again, there is a form for computing child support. Most firms, though, utilize software that you plug in the numbers and it will calculate the support for you. FinPlan is the program that my office utilizes for calculation of child support and spousal support. It's probably one of the more widely utilized programs for doing that. They research governing law, including any pertinent jurisdictional issues. They gather information and documents pertaining to financial resources, income, children's needs, standard of living, parenting plans, expectations and motivations, etc. They draft child support provisions for inclusion and separation agreements. They draft complaints, petitions, affidavits, responsive pleadings, proposed orders, materials in preparation for trial, etc. And they draft discovery requests. There's a lot that goes into child support calculations and a lot that goes into finally arriving at agreed upon child support calculations. Again, take a look at the Ohio guideline worksheet to give you a sense of what's included in income in the state of Ohio.